As Lauren mentioned, I'm going to be speaking today about the new donation tax credit rules, specifically about how those rules apply on death and to estates and the changes that were proposed a couple of years ago and that have come into effect beginning this year. Just a quick rundown of what we're going to go over. I'm not going to run through this, but there's a table of contents there for you. So prior to 2016, we had very specific and limited rules that allowed for the claiming of donation tax credits for donations that were made on death by an individual. And in 2014, we got a package of legislation from the Department of Finance that was mostly targeted at destroying all the planning that had gone on for years with testamentary trusts. And those changes were on the whole negative. But buried in that package were some really nice changes to the way donation tax credits work on death and by estates, providing a lot more flexibility than what we had at the time. And in fact, in January of this year, another package of amendments was released that provides even further flexibility. So while we're used to the government, not doing the best in changes for the taxpayer community, we have seen some really nice strides in this area. So in order to fully appreciate where we are now in 2016, we should look back at where we were prior to this year and to rules that still affect people that passed away prior to this year. And basically what happened was that if you had a gift that was made in the year of death, that gift was deemed to be made in the preceding taxation year. And the implication of that was that you could then claim the donation tax credit in that preceding year when the gift was now deemed to be made, or you could carry it forward 1 year to the year of death. And there was a special deeming rule for a gift that was made by an individual's will, and it was deemed to be made immediately before the individual passed away. So then again, it would fall into the other deeming rule that would deem it to be made in the preceding taxation year. And effectively, you had gifts that were made in a will that could be claimed in any of the year of death or the preceding year. The problem with those rules is that they were actually quite narrow. CRA had a very narrow interpretation of what a gift made by will was. It was basically an amount that the charity is entitled to receive can be determined by reference to the will at the time of death. So you couldn't have any flexibility. You couldn't say to the executor as well, if we can provide for these things, then we're going to make some charitable donations. You had to be very specific. And if you had any life and trusts in the will, you had to even be more specific that the residue or the gift over after the termination of the life interest trust was going to go to the charity to make sure that when that life interest trust terminated, such as a spousal trust, that you could get that donation tax credit claimed. And the problem with these rules, given how narrow they were, is that if you didn't fall into them, and if the gift was not deemed to be made by the deceased, then it was made by the estate. And there, the estate only could benefit from the normal, carry forward of donation tax credit, same as you and I get from making a donation tax credit. You claim the donation in the year that you made it, or in the 5 years going forward. There was no carry back available if the donation was made by the deceased. So the new rules, the 2016 rules, are a significant overhaul to what we currently had. We no longer look at this gift by will concept. We no longer have a deeming rule that carries us back into a year before death and those things. What we really look at now is who made the gift, when was it made, and what was the subject matter of the gift. And if you can get good answers to those three questions, then you're going to get good treatment for your donation tax credits. These rules came into effect on January 1st of this year, and they apply to any deaths from after the end of 2015. So if your client died in 2015, they're not going to be affected by these rules, but for deaths beginning in 2016, they can benefit from these rules. So basically, if you meet certain conditions, and those conditions I'll come to in a second, the gift will be deemed to be made by the estate and not by any other taxpayer, so not by the deceased individual, but by the estate. And it will be deemed to be made at the time the subject matter of the gift is actually transferred to the charity. So we're no longer looking at making sure you have the right wording in your will to be deemed to have a gift made by will. Your estate inherits the property, it makes the gift, that's when the gift is made, and as long as the timing of that is right, and I'll come to that in a second, you're going to get deemed to have the good deeming rule apply. So what are these conditions? Well, the estate must have arisen as a consequence of the death after 2015. So as I said before, only 2016 and going forward. And the gift must either be made by the deceased in their will, be deemed by subsection 118.15.2 to have been made in respect of the death, and I'll come back to that in a second. It deals with life insurance and the proceeds of registered plans, or have been made by the estate. So if you have, again, a death after, beginning in 2016, and you have one of those three types of gifts, so a gift by the deceased, a gift of a plan that qualifies with the deeming rule, or a gift made by the estate, then you're going to get, you're going to be deemed to have the gift made by the estate and not by any other taxpayer. And there is some special treatment that applies if the gift is made not just by an estate, by a graduated rate estate. So before we come to what the special treatment is and what the benefit of these rules are, just a quick overview of what a graduated rate estate is. So it's an estate of an individual at any time that arose as a consequence of the individual's death if the time is no more than 36 months after the death. So this is really the key one, is your graduated rate estate only exists for basically 3 years post-death. The estate must be a testamentary trust, so you still have to watch out for testamentary trust status. You can't have anybody transferring anything into the estate after the estate has arisen that's going to cause you to lose your testamentary trust status. And then you have some filing requirements, but important to make the designation in the first tax return for the estate for its first taxation year, saying this is the graduated rate estate. If you fail to make the designation, you're not going to get the treatment. It's not going to be a graduated rate estate, and you're going to lose out on the expanded DTC rules. So recall that under the prior system, if you had a gift by will, you were claiming that gift in the year of death or in the year before. And if the gift wasn't by will, it was by the estate, and it was being claimed only by the estate going forward. So now we have a gift that, a rule that if you fall into this, another deeming rule, subsection 118.15.1, then the gift can be claimed either by the deceased individual in the year of death or the preceding year, by the graduated rate estate in any of its taxation years, or by the estate itself under the normal rules. So this really gives you a lot of flexibility in terms of which taxpayer can claim it and how long you can claim it for. And at the end, I'll come to what I think is a sort of good timing opportunity for making a gift to show just how much legroom or how much length you can get out of a gift. So when does this subsection 118.5.1 apply to a gift? That's the key here. It applies where the gift is made by the graduated rate estate. As we've said a couple of times, the death occurs after 2015. And either it's one of these gifts of a registered plan to which subsection 5.2 applies, or if the subject matter of the gift was property acquired by the estate as a consequence of death or as property substituted for such property. And that's important. You're not going to get the benefit of this gift if it's some piece of property that the estate has acquired after the estate arose. And you're going to say, well, the estate's property, capital property is all going to be what it inherits. But some estates, drag on for a couple of years, and they could have income-producing properties. And if your executors are prudent, they might be taking that income that comes into the estate, and if they don't have to distribute it, they're further investing it. And if they do that and they acquire additional assets using estate income, those assets would not be assets that would be substituted property because they'd be from this new stream of income, and they would not be assets that were acquired from the deceased. And so they would not qualify for this treatment. So it is important to keep track of what assets came into the estate on death, what other additional assets may be acquired by the estate, and which ones are being gifted to make sure that we can fall into these rules. Now, we've spoken a little bit about the deeming rules for registered plans and for life insurance. This rule is a carry forward of the prior rule. Basically, what it allows you to do is you can make a direct designation of a qualified donee, one or more qualified donees, as the beneficiary of your life insurance policy or of your registered plan. And you can pay the proceeds of that plan or policy to the charity. And this rule will deem the transfer from the plan or the policy to the charity to be a gift made in respect of the individual's death. And so we saw that language came up a little bit earlier with respect to when a gift is going to be deemed to fall under the new rules. So it is important to fall into this rule with respect to your life insurance policies and your registered plans if that is the way your client is deciding to go. It's important, for some reason, they have a caveat on this rule. You cannot take the contents of the plan and gift it in kind if it's a registered plan. If you've got stocks and bonds sitting in the plan, you can't take those gifts, those assets, and gift them to the charity. They have to be liquidated. Only cash or a negotiable instrument will qualify for this deeming treatment. And so again, the benefit of this, just repeating it here, is that it's treated as a gift by the estate, and then it qualifies as a charitable gift. You get the donation tax credit, and it will fall into the same rules as, say, cash gifts or gifts directly out of the estate. For a number of years, we've had a beneficial rule in the Act dealing with gifts of marketable securities. If the estate had marketable securities and those are gifted directly to a charity, the capital gain arising on death from those marketable securities was deemed to be zero. That rule still applies. It's been modified a little bit so that it works with the new timing rules, that we're no longer looking at this gift by will concept, that we're now looking at gifts made by the estate. But again, the rule is still there. So if you're gifting marketable securities directly to a charity, the capital gain that arose on death is going to be wiped out. And marketable securities in this context is, any publicly listed share or debt obligation, shares of mutual fund corporations, shares of mutual fund trusts, certain insurance products, and prescribed debt obligations. And as I alluded to, there were some amendments that came out in January of this year. And the main amendment is a change to the 36-month period. So as we said earlier, in order to get into the good rule in subsection 5.1, the gift has to be made by the GRE. And implicit in that is the understanding that it would therefore have to be made within the first 36 months after death. The professional community said, well, maybe that's not enough time. The Department of Finance listened, and they've extended the rule to 60 months. So your GRE still lasts for only 36 months. They didn't give you any more time on that. But if a gift is made within the first 60 months of the estate, and if the estate would otherwise still qualify as the testator's GRE, so we ignore the 36-month limitation, but assuming the proper designations were made, no other estate is the graduated rate estate, and the estate still qualifies as a testamentary trust, then you'll be able to get the proper treatment or the beneficial flexible treatment for your donation tax credits for any gift that is made within the first 60 months of the estate. Now, there is an interesting little anomaly in the rule. We don't know if it was intentional or not. But what happens is that even though you can carry back flexibly to the deceased and his tax returns, if the gift is made in the sort of years 4 and 5, it cannot be carried back prior years of the estate. So the rule for carry back in years of the estate only applies to a gift made by a GRE. And if you're in years 4 and 5, you won't be a GRE anymore. So you'll be able to only sort of go forward with that or go all the way back to the deceased returns that the first 3 years you won't be able to carry back into the estate returns. Again, not sure why they did that, but that is the sort of anomalous way that the rules work. In the January package, there was some additional amendments made regarding spousal trusts. And just very quickly about spousal trusts. Originally, when you had a spousal trust, on the death of the spouse, there was a deemed disposition. The tax that arose from that disposition was the trust tax. And any donations that the trust made after death could be used to offset that tax. When this package of legislation came out in 2014, they changed that rule for some reason, and they made the tax the deceased spouse's tax. But the gifts and the assets were still in the trust, and there was this big disconnect. There was all sorts of other issues that I won't get into if you had second families and things like that, and who has the tax burden and those sorts of things. But a big issue was you had the tax arising in the deceased spouse's hands, and you have DTCs arising in the trust post-death. So they fixed that. The tax is no longer in the deceased spouse's hands. It's going to stay with the trust. And you have some flexibility in terms of, because you also have a deemed year-end that's coming with the new rules that wasn't there previously. And so you have some flexibility to carry donation tax credits back to the year of the spouse's death, so long as the gift is made by the trust for the filing due date for the year of the life tenant's death, and that's basically 90 days after the end of the calendar year in which the spouse died. And again, we have the same rule that the subject matter of the gift must be property that was held by the trust at the time of the spouse's death, or property substituted therefor. So if there's new property comes into the trust and you gift that, you won't be able to carry that donation tax credit back. So in the last 2 slides, just very quickly, we have some planning opportunities. The one I really wanted to draw your attention to is the third one here, which is timing for making a gift. So if you have a testator that has left charitable intentions in their will, and you want to make the gift, I would suggest making the gift in the 3rd year of the GRE to get maximum flexibility. If you do that, and assuming everything else qualifies, you're going to get the carry back to the year before death, the year of death, all 3 years that the estate is a GRE, and then the 5 years going forward from that under the regular rules for estates. So a lot of flexibility there if you time it right. I mean, of course, if you don't, you still have a good deal of flexibility, but I think that maximizes your flexibility. And just some things to look out for. Timing is important. You can't dilly-dally around. You've got to get this done in the first 5 years. Track your assets. Don't accidentally gift an asset that was not part of the estate when the estate arose. And don't forget to make the GRE designation and maintain your testamentary trust status, or none of this is going to apply, and you're just looking at the regular 5-year carry forward. Thank you.
Okay, I guess I'm on the air now. Is that okay? Morning, everyone. For starters, the material includes a paper that I write every year for the Canadian Donors Guide, so that's a takeaway you can look at when you've got some more time. It's kind of a survey of largely from the perspective of donors rather than donees, but it covers some of the compliance issues as well for the recipient. So I've got quite a bit jammed into my PowerPoint. I'm not going to cover everything in detail, probably not even everything at all. So my approach is really to start off with two basic approaches. One is people giving to charity, and I use charity loosely here. Cliff's going to talk about what a qualified donee is. It's more than charities. It includes the Crown, some foreign organizations, other entities in Canada. And then the second part of this is more from the perspective of people who want to do more than that, and that's remain involved, perhaps through forming their own charity, which could be either an active charity, charitable organization, and getting it registered, which is a chore in itself, or perhaps forming a private foundation, which is more of a fundraiser and a conduit, subject to more restrictive rules. And in between those, you have what's called a public foundation, which is, again, inactive, but more broadly based and more flexible because it's less regulated by CRA. So having said that, the typical question I get from largely often wealthy clients who are thinking of donating is, how do I form a private foundation? And the question then is, why do you want to do that? Because there are alternatives. You can achieve largely the same thing by agreeing with a public foundation to create what we call a donor advised fund. With a private foundation, you've got startup costs. You have to incorporate it. You have to get it registered with CRA, which even for a slam dunk these days takes months. And then you've got not only the startup cost, the ongoing administration, tax filings, corporate filings, CRA compliance, which is more stringent for a private foundation than a public foundation, especially if you want to deal with shares of private companies or do anything that even smells like being a business. You can't do that in a private foundation. And even active charities will be called private foundations if they have a closely held board of directors. So the nomenclature is not always clear. So if you want to have an active charity, number one is you've got to have a broadly based minimum of 3 directors with 2 who are arm's length. So that whole registration process is an ordeal in itself for active charities. I'm not going to go into that in any detail other than to say if that's where you want to go and your clients are more interested in writing a check and getting a receipt, then that's a whole other exercise. So the choice, if they do want to have a private foundation, that's simple enough to do. Why would you want to do that? In my experience, there are a number of reasons why people think they want to do it, and I've listed some of them here. I guess I should follow my... So people talk about succession. Typically, dad is fairly well off, donates a lot. He's going to leave a lot in his will. Thinks his kids should become philanthropists. They're not going to get it all. So he says, well, let's teach them now about philanthropy. So I'll sit them on the board of my private foundation, and they'll manage the money and decide where the money goes. So the private foundation is like a donor-advised fund. It simply gets money in and makes grants to other qualified donees. In my experience, very rarely do those kids buy in. They get told by dad they've got to show up at meetings or get involved. After a while, dad decides, this is a lot of time and effort. Let's wind this thing up and give everything to a charity and call it a day. You don't have any of that if you have a donor-advised fund because they do all the heavy lifting. The donation goes to the public foundation, which receives that money, and the legal distinction for tax purposes is that the donor, having made an irrevocable gift, then recommends what the charity will do with it. And I've never seen a situation where that hasn't happened, as long as the recommended charity is a qualified donee. So I give my $1 million to ABC Foundation. They set up a fund in whatever name I choose. It's their money. But every year I say, well, let's give X dollars to that charity, and they do it. It's their decision on my recommendation. That's the legal distinction. The other thing about forming your own foundation is you've got provincial law to worry about. You don't have to worry about any of that if the public foundation is doing all of this. But in Ontario, we have a government agency called the Public Guardian and Trustee that oversees charitable property in the province. So they are involved even if you form a federally incorporated corporation and register it with CRA. If you have property here, the PGT will be in on the action. And then even if you do get registered, as I said, you're subject to annual filings, and conceivably you could be audited. And if you're audited and flunk, you're subject to sanctions, the worst of which is revocation. So those are all the potential downsides of having your own foundation. Some of the other points about public foundations and donor-advised funds, they charge a fee for this, and that's often not negotiable, but it's different depending on the foundation. I'm on the board of a large public foundation that's raised several $100 million. We have a set fee which is graduated for how much money stays in a particular fund, and if you want to put the money in and pump it out in 3 weeks because it's December 29th and you want to get a receipt, you give the money to the foundation, it issues the receipt, and if you then decide what you want to do, or even if you've applied to register your own private foundation and that gets registered 4 months later, the money goes out to it, but you've accelerated your donation receipt. So not all public foundations are that flexible, but certainly that's the concept. And that you get the receipt from the public foundation, not from the ultimate charity that you've chosen. So you give it to the public foundation and say, give it to the Red Cross. The Red Cross will get a letter from the other charity, which may or may not say, you know, thanks to Mr. X. And they'll disclose that if Mr. X wants it. Just in terms of donating generally, one of the things people do or should do is to investigate the charity that they're donating to. There's information available. CRA has a website that I guess isn't, I think it maybe is available to everybody if you have the service. It lists all registered charities and posts the information about their annual tax return called the T3010. That return discloses their income, their expenses, and various other breakdowns of what they're spending on administration, et cetera, et cetera. So that's a start. You hear all this discussion about charities that are not efficient. Well, that's a starting point. So some of the one other observation, and this is the current slide here. Not-for-profit organizations are not registered. They're a whole different animal. So if you donate to them, you don't get a receipt, although businesses might get a deduction for business promotion or advertising. So giving to the Lions Club is different from giving to the Red Cross. You have to be aware of that. There are a number of receipting issues. The charity has to disclose the right amount. If you get an advantage back, it has to measure that and deduct it from the number on your receipt. That comes into situations where there are incentives, little things like getting a pen or a coffee table book you don't worry too much about, and there are guidelines on this. Larger things like giving millions of dollars to a university and having your name plastered on the front of a building, that raises different issues about whether that has real value and therefore should be deducted. And that isn't entirely clear. CRA's got some comments on that, which I'm not really going to go into anymore here. So I've already talked about those points. There are issues about receipting, which I just mentioned. So the donor wants a receipt, obviously, for the maximum amount he can get. That's his tax reason for doing it. Believe it or not, some donors are less motivated by tax receipts than by actual philanthropic incentives, so they're less concerned about the receipt. But in any event, the receipts are important. There are issues about conditional gifts. Can you give money to a charity and say, you must do this, and if you don't do it, I get the money back? There are legal issues about that. There are charity law issues outside the Tax Act dealing with whether you can get money back or not. A couple of years ago, they changed the tax rules to specifically deal with the situation where a charity gives the money back. It sort of reverses things, takes away your gift in the year in which you made it and gives you an inclusion in the year in which you get it back, and the charity has to report all of that. Types of donations, as you can imagine, there are all kinds of things you can give. Cash is easiest. Marketable securities, there are incentives for that. If you donate the right type of marketable security, you don't have to realize a capital gain, but you still get a receipt for the full amount. So that's quite an advantage. If you sell the asset and give the money, you're worse off. So you want to donate the marketable securities in kind. Other things like art or real estate, private company shares. There are often difficult issues about valuation, especially real estate or private company shares. If there's no market and no activity, you need an expert to give an opinion, which CRA may or may not accept. There are special rules for ecological property and cultural property. You don't have to realize a gain when you give those, but you still get the full value for your receipt. The government introduced changes in 2015, the Harper government, which were not continued by the Trudeau government, that would have given more relief for people who have real estate or private company shares. There's a lot of money tied up in those investments, and people are tax trapped because if they sell it, they get humongous gains on the shares of the company or on the real estate. And with commercial real estate, you have recaptured depreciation as well. The proposal was that if you sold those assets, real estate or private company shares, and within a short period of time gave the money to a charity, you didn't have to pay tax on the gain, except for recapture on a commercial building. It was quite restrictive, but it was certainly better than nothing. But the current government didn't continue that, so we're back to square one, that trying to donate real estate or private company shares remains problematic. There are different ways of doing this. Josh talked about doing it by will or on death. You can obviously do it while you're alive, which is more straightforward. You always want to think about the timing of when you can use the receipt. You can carry it forward for up to 5 years. You can't go backwards. And with these new rules, the estate also can carry things forward. In some cases, there are trusts people set up, for instance, charitable remainder trusts. You give the property to a trust, reserve the income to yourself or somebody else, and say when that person's gone, whatever's left over goes to the charity. Those were fairly common. Now they're more problematic because of these rules about gifts on death. As Josh said, you have to actually transfer the property to get the receipt. So when you give a charity a future interest in a trust, it appears you haven't actually transferred anything that entitles you to a receipt. A couple of other observations. Foreign organizations, some people want to donate to foreign organizations. Some of those are qualified donees, such as the UN. Cliff will talk about this a bit. CRA has a list of specific organizations that it identifies because it thinks they're doing good in Canada, largely through disaster relief, and there are others. Outside of all of that, we have a treaty with the U.S. So if you want to donate to a U.S. organization, there are limited circumstances in which you get relief for that. The most straightforward one is if you have U.S. source income and you pick the right charity that CRA recognizes, then you can give to it up to the same 75% limit that applies to all of your income based on your U.S. income. So the overall limit in Canada is you can't zero out your income by giving it away. You can only get down to deduct 75%. And that rule applies to your U.S. source income if you give to a U.S. organization. The exception to that is in the year of death, where you get 100%. There are a few wrinkles on that one. The treaty says that you can donate, even though the Income Tax Act says you can only donate to a qualified donee. So there's a little bit of a mismatch there. People have argued that the treaty therefore means that that U.S. organization must be a qualified donee, and therefore a Canadian registered charity can make a grant to it. Charities in Canada can only make grants to other qualified donees. So the $64 question is, can a Canadian registered charity give to a U.S. organization that is recognized under the treaty, to which a donor can make a donation and get tax relief? CRA says no. The Federal Court of Appeal has ducked it several times, so it's an open question. I'm not sure on that one myself. I think the better view probably is that it should work, but until that one ever gets to the Federal Court of Appeal or higher, I guess CRA has the upper hand. And just on that point, in tax law, CRA is right when they assess you until you prove they're wrong, whether that's in your business or individual tax situation or with a charity. So they assess, they're right, you have to prove they're wrong. So if you are denied a deduction, you have to go to court eventually. If a charity is being sanctioned, it has to fight it. And if it can't successfully fight it, it's subject to a variety of penalties, including suspension of receipting and ultimately revocation of its registration, which is the atomic bomb. So charities are very leery of getting into that sort of trouble. There are some probate tax issues that often come up. In Ontario, when a person dies and property passes under a will, the Ontario government gets its hand into the situation, charges an estate administration tax of 1.5% based on the value of the property that passes under the will. So if you leave $10 million to a charity through your estate gets the money, pays that tax, and then makes the donation to the charity, which works for income tax purposes but doesn't help you with probate tax purposes. There are some tax rules that help in that regard. If you designate the charity under the policy, then it doesn't go through your estate. Similar rules for RRSPs, RIFs, and TFSAs. You can directly designate so the charity's the beneficiary, doesn't go through the estate, and therefore you save the estate administration tax. Lots of people do a lot of complicated planning to deal with that. In my experience, it's often not that big a factor, and sometimes I think you should just let it go because, as I indicate, the tax tale shouldn't be governing here. Life insurance is often a big part of charitable giving. As I just mentioned, you can have a policy, collect the proceeds, and have your executors give it to charity. You can designate the charity as the beneficiary. You can donate a policy while you're alive, continue to pay the premiums. And a current policy may have some value, so there are tax issues on that. You're entitled to a receipt based on its fair market value. You need an opinion from an actuary as to what that is. And when you donate something, the tax rules indicate that there might be an income tax inclusion based on the adjusted cost basis of your policy, so you have to watch out for that. There are complicated rules that generally deal with private companies, and these are a throwback to the good old days when aggressive tax planners would say to a wealthy entrepreneur, you have a private company with tons of earnings, so we're going to pump out a huge bonus to you to get down to the small business rate for the company to pay tax at the lowest rate. You'll pay tax on that remuneration But the good news is you can make a donation to a charity and get a receipt. And don't worry about the fact that you don't have any cash, because we'll use promissory notes. So the charity has a note that you owe to it, or the company owes you, and you donate the note to the charity, and the charity issues a receipt. And in some cases, the company would buy a life insurance policy on the life of the individual, so that when he dies, there's real money available, and the charity gets the money at that point. CRA didn't like that, nor did finance, so they brought in rules dealing with non-qualifying securities that are still there and are specifically a problem for private foundations. Another reason why donor-advised funds are often a better vehicle. I've seen situations where families have come forward to a public foundation and a donor-advised fund to give the shares of a private company for that very reason. These can often be estate-free shares where Dad froze his investment in the company years ago, took back high-low retractable shares. The next generation or a trust has got the growth shares. Dad is now sitting there with a lot of value in these retractable shares, wants to help a charity, wants to donate them. In theory, they're worth their face amount because the charity can call for a redemption at any time. Dad doesn't want that to happen, so he wants some kind of understanding from the charity that it won't do that until he's gone. So that's a separate issue. But that's the kind of situation you often see with private companies, where you're trying to match Dad's planning for his succession and death with the value that's locked into the shares of a private company. In some situations, the planning might actually involve the company being the donor. I had a situation a few years ago where the deceased left the shares of an investment company to a large charity. The investment company had shares of a formerly active subsidiary. We suggested to the executors that they wind everything up and give cash to the charity. The executors insisted, take it or leave it. You get the shares of the company or you get nothing. So that involved a whole bunch of issues about potential liability, tax inside the company on the assets that had appreciated. So it was quite complicated. And of course the charity had to step in and take over by appointing its directors of both companies, leaving the former active company around for quite a while to age it and hope nothing came out of the woodwork in terms of liabilities. So that's the sort of thing that often comes up when people want to help a charity with private company shares. Even where it appears it's a straightforward slam dunk because all the company has are marketable securities. So, and some people build that into their wills to provide the executors with flexibility in either transferring cash or assets to the charity or causing the company to transfer the assets to the charity if they're marketable securities. The company gets the same benefit of non-recognition, but it gets the added advantage when it donates marketable securities. It gets in addition to its capital dividend account, believe it or not, even though it doesn't pay tax. So that's a bit of a plus. So there's been a lot of case law on charitable donations, as I'm sure you're aware. Over the years, CRA has been attacking these things like crazy. There were some very aggressive plans going back to the beginning of the 2000s, often where it seemed too good to be true. The typical situation was you buy something low and you donate it high. So somebody comes along and says, you can buy this wonderful piece of art for $1,000, but trust me, it's worth $10,000. So we'll get an evaluator to tell you it's worth $10,000. You give us $1,000, we'll arrange all of this, and you can donate it to a charity and get a receipt for $10,000. The obvious problem with that is CRA doesn't think it's worth $10,000, and there was lots of litigation on that. And as I said, all they have to say is no, and you're in the soup because you have to go to court. More sophisticated issues then came up where you put the money in and you borrowed it back, or you had an option to get a loan or that sort of thing. There was uncertainty about that, but the Federal Court of Appeal has said definitively, and the Supreme Court has decided not to review it, that in those cases, if there's an advantage at all, even if you've paid cash, believe it or not, you write a check and you're out of pocket for the cash, they say that's not a gift. So not only don't you get the receipt for the high amount, you don't get a receipt for anything. Well, you get a receipt, but they don't allow it. So you're completely hosed if they don't like that sort of planning. There aren't too many of those around now. The rules were changed in 2002 to deal with what we call split receipting. That regularizes what had been a practice. If you went to a charitable fundraiser and wrote a check for $500 and got a rubber chicken meal worth $100, they used to administratively say deduct the 100 from the 500, issue a receipt for 400. That's now the law. So the charity has to measure whatever that advantage might be. And that's often not that clear if the advantage isn't something that's tangible and easily measured. Naming rights on a building, for instance, would raise that issue. So Josh already mentioned the issues about testamentary gifts, valuation issues. That's always a problem, especially for unusual assets. So just what's this all about? I mean, people want to donate to charity. The question is why? If they're interested in tax receipts, that's one issue. If they really think that's an adjunct to giving and they write a check, that's usually pretty easy. As advisors, you often want to give them some guidance in picking a charity if they don't have a passion for one that they're very familiar with. Not all charities are equal. As we know, some are more efficient than others. There are reputational risks involved. Some people prefer education to health to various other things. There are tons and tons of charities out there. I think 90,000 registered charities or something like that. Donor advised fund is often a very useful alternative. Political activity is something you have to worry about. Sorry?
I have a question. You mentioned that often subsequent generations aren't as interested in participating in a foundation that maybe the father had organized. So are you noticing trends in terms of how private foundations are structured, such as possibly structuring them as trusts with a trust company managing it rather than family or other people, and also are donor advised funds becoming more popular?
The question is succession with private foundations and trying to build in some kind of mechanism up front, and whether that's being reflected in donor advised funds. The donor advised fund solves that because you can clearly have other people come along as the advisor later. So with the private foundation, there are some corporate law issues about how you entrench that in your constitution to make sure that, you know, 2 generations from now, your health-oriented charity doesn't become something that's aimed at saving the environment or something. The best rule is to sort of trust your directors that they'll always ensure their successors think like they do. The governance model that's most common is the directors are the only members. So if you have 3 directors, they're the only members. The members appoint the directors admit the members, and it goes on. But if there's nobody interested in doing it, you could appoint a trust company, and they charge for that. Trust companies are often hired or advisors. If you have a lot of money, then it has to be invested properly. The directors are fiduciaries, and they're responsible to manage the money properly. So that's certainly an issue ongoing about, rather than winding up, is there a way to try to keep it going? I guess that's it. Okay, thank you very much.
Hi, is this working? Okay, so I'm going to talk about two things, actually. The first is the one that's announced, which is carrying on activities through the use of an intermediary. And if there's time at the end, and I hope there will be, I'm going to talk a little bit about an even hotter button topic these days, and that's charities which are carrying on political activities. So the starting point, I always like to start with either a quote or a joke, and I usually like something from Sherlock Holmes or Winston Churchill. This is a charitable session, and the only jokes that Sherlock Holmes joke I could think of involved charitable deductions, which wasn't very funny, so I didn't go there. For Winston Churchill, I'm mindful of the fact that we're here to learn, and he said, "I love to learn, but I hate to be taught." So I'm going to try not to teach you, but I'm going to try and help you learn. So the starting point is that a charity has to devote all of its activities and all of its assets to charitable purposes. And it can do that by giving its assets to a qualified donee, and I'm going to deal with that. And then I'm going to go into how a foreign organization might become a qualified donee. And I'm going to talk about how if you don't have a foreign organization that is a qualified donee, you can still carry on your activities outside of Canada. Actually, the same rules also apply inside of Canada, but we're talking about mainly about outside of Canada, but you can do the same thing inside Canada. So a charity, as I said, can accomplish its charitable purpose by carrying on its own charitable activity or by giving its assets to a qualified donee. And qualified donees are defined in the Income Tax Act, and they include all registered charities, certain other Canadian entities, and those are registered Canadian Amateur Athletic Associations, CAAA as they're normally called, registered Canadian National Arts Service Organizations, housing corporations, which are specific types of housing corporations, a Canadian municipality, a municipal or public body performing a function of government in Canada. There's a lot of case law about what that is, but a public library board, for example, would qualify, and the Government of Canada or a province or its agents. And there's also some foreign entities that are considered to be qualified donees. So the United Nations and its agencies, prescribed universities outside Canada whose student body ordinarily includes students from Canada. At the back of the Income Tax Act, there's a whole list of these things, and they're in virtually, I wouldn't say every country of the world, but most countries, and virtually any university outside of Canada you've heard of would be on that list. And then there's foreign charitable organizations outside Canada to which the government has made a gift during the current and the preceding taxation year. So there's the rules on this changed recently. It used to be that once you're on the list, you stayed on the list pretty much indefinitely, but the new guidance, which actually came out, it's CG 023, was published on June 16th of this year, so it's quite recent. For a 24-month period, if a charity is carrying on at least one of relief activities in response to a disaster, provides urgent humanitarian aid, or carries on activities which are considered to be in the national interest of Canada, you can get on the list. And I haven't checked it in the last week, but as of September 6th, there were 2 registered foreign charities which are considered to be qualified donees. One is the Aga Khan Foundation, which is in Switzerland, and the other is the Woodrow Wilson International Center for Scholars in the USA. There's several that were on the list but have expired, such as the Poland Auschwitz-Birkenau Foundation, the Rhodes Trust, and something you probably never heard of, the Bill Hillary and Chelsea Clinton Foundation. It's not on the list anymore, but they might be. So Canada is different than other countries. I often get a phone call from a foreign organization wanting to have a Canadian charity set up, take the money and give it to us, great. We have this in the States, we have it in United Kingdom, we have it in South Africa, no questions asked. And I always say we're different. And well, how different are they? Most countries will allow direct gifts to organizations which would qualify as charities. For example, under the U.S., a 501c3, which is the equivalent of a registered charity in Canada, can simply give its money to an organization which the IRS would recognize as a registered charity if it were in the United States. So, for example, this is public. I've set up the American Friends of the Toronto Public Library, and it's a way of, it was set up actually for the benefit of the special collections, raises money for the Osborne collection of early children's literature, the Arthur Conan Doyle collection, and so on, and also for just Friends of the Library. And Americans can give money to that foundation, which then give its money directly to the Toronto Public Library or the Toronto Public Library Foundation, no questions asked. You can't do that in Canada. You must maintain direction and control. And direction and control, we'll talk about that a bit. And the charity has to carry on its own activity. It can't be a conduit. You can't simply give money to a Canadian charity and it just gives the money to another charity. And we'll come back to that in a little more detail later. So there's 4 cases I just wanted to point out. These are typical cases. They're most of them recent. And the first one, actually, Public Television Association of Quebec and Canada. That's quite a cause célèbre in Quebec. Many years ago, the Quebec, I think it must be the Public Television Association, set up a charity, and they made an arrangement with Vermont Public Television where the Quebec organization would raise money, give charitable receipts for it, and then use the money to fund programming that was actually being produced in Vermont, or which the Vermont Association was buying from public television in the United States and showing. And of course, in Quebec, you can catch the Vermont stations because they're quite still on the southern boundary of Quebec. So this went on for a number of years, and the Quebec was paying for program packages, including children's cartoons like Caillou, adult television shows like the Nightly Business Report, and there was a written fundraising agreement in place between the two under which the Vermont Public Television would raise funds from Canadians as PTAQ's agent, and PTAQ would issue the donation receipts. So they have these membership drives. The money would come in, but it would go into the account of the Canadian organization, which would then fund it back to the Vermont organization. And CRA looked at the situation, and they said, well, all PTAQ is a conduit to raise money for Vermont. There was no evidence that there was any direction and control from the Quebec organization over Vermont Public Television. Quebec was just simply selecting from a list of programs that Vermont Public Television had anyway. And as a result, because they weren't monitoring the fundraising costs, they weren't monitoring the broadcasting, et cetera, they were just picking from a list, that was a violation of the monitoring and reporting requirements, and that was you're acting as a conduit, and they were deregistered. The ISNA Development Foundation, this is a Muslim organization. I'm going to be sort of equal here. I'm trying to pick from every, well, not every religion, but just to give you an idea that CRA is not denominational. They'll go after anybody, regardless of race, creed, religion, sexual orientation. I think I haven't seen any of those. But again, this was, the ISNA Foundation they were not exerting direction and control over the funding. They also thought there was a possible funding of a terrorist organization, which is obviously a no-no. There's, in addition to the Income Tax Act provisions, there are several other statutes that charities are subject to relating to funding of terrorist activities, and they simply thought that there was the Pakistani organization that was being funded was the Relief Organization for Kashmiri Muslims. There was no direction and control. The relief work that was done dispersed something like $300,000 to the organization in Pakistan, and the CRA determined that the Pakistani organization was the charitable arm of Jamaat-e-Islami, which is a political organization that actively contests the legitimacy of India's governance over the states of Jammu and Kashmir, and that it funds a Mujahideen organization, which is listed as a terrorist activity, and therefore it was deregistered. The ASL Charity Foundation, which is a Jewish organization, lost its registration because they didn't maintain direction and control over the monies that were sent to an organization in Israel. They didn't have adequate books and records, and the Bethesda Missionary Temple of Canada gained direction and control in acting as a conduit. So these are obviously very important issues. If you are going to set up a Canadian charity to raise money for a foreign activity, it can be done, but this is the way not to do it. CRA has published a substantial guidance called Canadian Registered Charities Carrying Out Activities Outside of Canada. I've given you the URL. And a second one on using an intermediary to do the same thing within Canada. And in either case, they're the same rules. So what is an intermediary? Because that's how you're going to carry on your activity. So there's three kinds. There's agents, there's partners, and there's joint ventures. So if you use an agent, but in reality, by the way, any one of these three, the rules are more or less the same. The agreements are slightly different. There are a few minor differences in the principles, but the object of the exercise is to get it right, to dot the I's and cross the T's, and to maintain the arrangements in effect, not to just say, okay, I put the arrangement in place, I don't have to do anything more. So the first step, and this will be something that CRA asks for, when you apply for registration, they will ask you for a copy of these agreements and a detailed understanding of how they will be carrying on these activities. So the first thing is an agency agreement or a joint venture agreement if you're joint venturing with another charity, for example. I've done them with, for example, Canadian and U.S. charities agree to do a project somewhere in Africa, for example, and you can set up that they'll both fund the same project depending on what it is, or they'll fund different aspects of the same project. But in the end of the day, the agreement has to be very specific about maintaining control over the funds, getting back adequate reporting, including detailed expense accounts, making sure that the Canadian organization is active in selecting the project, reviewing the carrying on of the project, either by having someone go over there on a regular basis or having a local agent who's generally not, should not, probably must not be a part of the organization that's, you can't ask the organization that you're funding to monitor itself. So, if the president of the Canadian organization routinely goes to Africa once every 2 or 3 months and is able to, inspect and determine that the activity that's being carried on is what was agreed for, fine. If you have local agents on the ground, which is often the case when you have ethnic-based organizations, there's someone back home who is not part of the local organization that's actually doing the work on the ground, can be the agent for the Canadian organization to go and look at the project and make sure, if you're building a schoolhouse, that the money is actually being used to build the schoolhouse. Then the money is being used to pay the teachers. And so then on-site supervision is important. It's very important for the accounting records and the invoices that come back either to be in French or English, or that you have translations of them. The CRA, when the auditor comes in, if the auditor often could read the foreign documents, but in essence you have to have them in French or English. And then there's a sort of a subplot involving capital property. If you're building a schoolhouse, CRA's policy is that you have to own the schoolhouse. This is not always possible. First of all, you may be doing a joint venture with other organizations, or I've acted for organizations that built schoolhouses where the school was going to be owned by the local municipality once it was built. They will on occasion make an exception. They haven't published it. They have said they would They have said they would publish it. They then said they changed their mind. They will give you on a case-by-case basis, for example, if you're going to build a schoolhouse in a place where they think the government is stable, and you can get a letter from the government saying once the schoolhouse is built, we'll operate it for 20 years as a schoolhouse, CRA might give you a letter saying that's fine, you can go ahead and do it. But if you actually want to build and spend money on capital property in a foreign jurisdiction and you don't own it, you are very much risking your charitable activity if you don't get CRA approval. So I want to deal now with political activities, which is not listed, but in the program, but I do have some slides on it. So first of all, under the Income Tax Act, charity cannot have a political purpose, but a charity is permitted to engage in political activities under certain circumstances. So I want to just point out that for CRA purposes, for charity purposes, there's two concepts. One is your purposes, the mission statement that you are incorporated in and registered as a charity to accomplish, and then the activities that you carry on in order to support that purpose. And CRA, when you now apply for a charity, you have to give CRA the full details on both. So your purposes are your objects if you're an Ontario corporation, or purposes if you're a federal corporation, and they're set out in your incorporating document. If you have a trust, that's the purposes for which the trust would be established. And your activities are the things that you do in support of each purposes. And each activity that you do in support of your purposes has to be charitable in itself. And CRA asks you for excruciating detail on what that activity is going to be. So if you're going to carry on an activity overseas, what's the activity, what projects are you going to carry out, what's it going to cost, how are you going to monitor it, if you're giving scholarships, if your purpose is an educational charity and you're going to give scholarships to people to enable them to study mathematics, where are the scholarships usable, how are you going to select who gets the scholarships, are you publicizing them to the entire world, is this, are you, make sure you're not doing it for the private benefit of, members of your family or your neighborhood or something like that. And they literally subject you to cross-examination. And our experience in the last few years is that even if you try to anticipate everything that's going to come back from the CRA, something's going to come back that you didn't anticipate because the individual examiner is involved. But let's get into political activities. So you can have political activities under certain circumstances, and they are that they can't be partisan, they can't use more than a specified percentage of your resources, and if there's an election going on, there's additional restrictions, which I don't intend to get into. I think everybody's well aware that in the latter stages of the Harper government, there was a very controversial program. Some people, depending on whether you're a conservative supporter or a liberal supporter, the conservatives' view is that the government got upset because a lot of charities were engaging in political activities which seemed to be beyond what was permitted, and they wanted to have an audit. The left-wingers, the liberals and the New Democrats, are saying the government did this because they're targeting left-wing charities. I don't think there's a real complete answer on that, by the way. But the CRA was given additional funding to do 60 audits to determine whether these charities were carrying on political activities, and they weren't just the environmental charities, they were all types of charities. And as of August 2016, 38 of them have been completed, and there were 24 ongoing audits when the Liberal government took over, and they said, what we're going to do, we're not going to do any more, but the existing 24 will continue, and there's 16 of those still ongoing, and there were about 6 that were canceled where they didn't get started. So CRA's approach has always been, they do an audit and they find things that they're convinced are not appropriate, they will do education first. They'll write a letter. They'll tell you that you're carrying on certain activities. You must cease doing them, or we'll come back and do something. Sometimes they ask you to actually sign an agreement called a compliance agreement. But the end of the day, if you don't carry on your activities properly, if you continue to do improper political activities, the final step, as Jim mentioned, is revocation. It's interesting, the results were that of all of the audits were completed, almost all of the charities were compliant. They gave notice to 6 charities that they were proposing to revoke them. Only one of those was for political activities. I'll come back to that. And my understanding is that all 6 are going to appeal the proposed revocation. So what are political purposes? Political purpose, and remember, you cannot have a political purpose, you can only have a political activity. But a political purpose is something that seeks to retain, oppose, or change the law, policy, or the decision of any level of government in Canada or a foreign country, or further the interest of a political party, or support a political party or candidate for public office. And they assume the activity to be political if the charity communicates a call to political action. In other words, you've seen them letter writing campaigns, write your local member of parliament to support a particular bill to end abortion rights or whatever, pick it. As long as it's a controversial thing and you get a letter writing campaign, that's a political activity. Or you can have communication to the public. You can engage in a public relations campaign that says that certain laws, policies, etc., are wrong and need to be changed or should be heavily supported or whatever. Or you could try and put pressure on an elected representative or public official to change or oppose the law. So those are what are considered to be political activities. Now, what are resources? Well, substantially all of the resources must be devoted to charitable activities. So that means anything that's more than the substantially all is available to be used for political activities. And in their case, what they said is you have substantially all means 90%. So if 90% of your resources are devoted to your day-to-day activities, feeding the poor, education, maintaining a place of religion or whatever, that you have that 10%. And if your revenues are actually under $50,000, they said, well, okay, you can have 20%. Between 50 and 100,000, you can have 15%, and between 100 and 200,000, you can have 12%. So you would think, okay, fine, I know what I've got. I've got $100,000 a year. I can spend $15,000 of that on charitable activities, but you'd be wrong because resources aren't defined in the Income Tax Act. So CRA, and this has not been challenged in court as far as I know, considers resources to mean the total of your financial assets, plus everything you can use to further your purposes, the staff, the volunteers, the directors, the premises, the refrigerator, the typewriters, computers, sorry. How do you measure that? I don't know. But CRA says if you can figure out that 10% of that is you have that available to you. Other charities, sometimes charities were trying to get around this by making gifts to other organizations that were less restricted and could therefore carry on their activities. But if you give a gift to another charity, that's considered to be which can reasonably considered to have been given for the purpose of allowing that other charity to engage in a political activity, then that's considered to be your political activity as well. So both charities then be hit with that. So when the new Liberal government came in, Diane Leboutillier, who's the Minister of National Revenue, said she had 3 top priorities. And one of them, and I'll just put it up on the screen, I'm not going to read it. So we're hoping. So what is the future? Well, there's rumors that there's new legislation coming that will deal with political activities. But the most important recent development, and this really is hot off the press, obviously, about 2 weeks ago, a charity called Canada Without Poverty, which is a very small charity, is one of the 6 charities that received notice of revocation of its charitable status. CRA determined that 98.5% of its activities were considered to be political. So even if it could reduce those significantly in the debate, it doesn't stand much of a chance of fighting off revocation based on political activities only being a small percentage of its activities. And it's decided that the way to do it is to go after the after CRA or the Income Tax Act. They're saying we're not mad at CRA. They're doing what they have to do. They're administering the law as it is. The law is wrong. It violates our freedom of expression and freedom of association under Section 2 of the Charter of Rights and Freedoms. And that's going to put a whole new perspective on this, although it might take a number of years to wind through the courts, and we may get legislation before that. But if this becomes the basis for the courts to determine what political activities are, it'll be very interesting to see what happens to this whole field. If you're looking for CRA's commentary, there is they're not entirely up to date and not entirely accurate in the opinion of the profession, guidance on what political activities are at that location on the web. And I thank you.
Well, that completes our formal presentation part, but we are certainly open for questions if anybody has. Okay. Again, a reminder, please, the evaluation forms, if you wouldn't mind filling them out and just leaving them here. Thank you all for attending and your attention, and we'll look forward to seeing you at the next Toolbox seminar.